And welcome back. Tonight we're talking about elder law. We've got with us Michael Timberlake from Senior Timberlake and League and Connie Glass from the Elder Law Firm. This is all she does all day long.
All day, every day.
We've got lots of callers waiting with questions. We've got Dee on the line from Huntsville. Hi Dee, thanks for calling. What's your question tonight?
I have a two-part question.
Okay.
What is a life trust, and if it is made up by a lawyer, signed by the lawyer, signed by the parties involved, and registered at the courthouse, is it binding?
A life trust.
Yes.
Don't have a clue. You could be talking about a living trust, or you could be talking about a life estate deed, and I'm not quite sure which one, so I'll try to briefly explain what those are. The life estate deed is if you own a piece of real estate, you can transfer what's called the remainder interest to someone else, sometimes your children, and retain what is called a life estate. That is the right to live on the property and use the property for your lifetime. That's signed by you, and it is recorded at the courthouse, and if it is signed by you and delivered to the remainderman and recorded, then it is a valid deed. A living trust is just a trust you do during your lifetime. Those are generally not recorded at the courthouse, so I'm not sure that's what you're talking about.
What's the benefit of a living trust? This is one of those things that it's kind of everybody talks about, and then some snake oil salesman will come try to sell it to you. Is it a good idea or a bad idea?
You know what I tell my clients? It's neither good nor bad. It's just a different way to the same end.
Right.
The goal is to get your assets where you want them to go. You can do that with a will, you can do it with a trust, you can do it with beneficiary designations. There's a lot of paths that take you to that same end. So I think there's not, again, one size fits all. You have to do what's best for that particular client.
Does a living trust keep it from going to probate?
Can, if it's properly funded, but what I find so many times is that people create the trust and then don't fund it. They don't actually retitle their assets into the name of the trust.
Right.
So they've got this beautiful trust document that doesn't control anything. So.
We've got Betty on the line from Decatur. Hi Betty, thanks for calling. What's your question tonight?
Yes, my father died 4 years ago, and in his will he declared that he wanted his real property to be sold and divided, and I have a sister who is not agreeable to this. Is that contempt of the will?
Okay. What happens when the people don't agree?
Well, you know, it really kind of comes down to who's the personal representative that he would appoint to handle his estate. The personal representative is someone that's named in the will typically, and they're, you know, most people will say, well, they don't have to have a bond, and it can be either a family member, or it can be a lawyer, it can be a trustee at a bank, somebody like that. But that person's in charge with gathering the estates, and then, you know, doing what he has to do to handle the creditors, and then he's got to disperse the assets of the estate in, you know, as directed in the will. So whoever the personal representative is would have to handle that, and if the personal representative doesn't do the right thing, then
they can be removed.
They can be removed.
Right. That person can be removed by the judge. Sometimes the judge may have to light a fire under that personal representative to make sure that they're doing what the will directs them to do. Sometimes the personal representative lets their own personal feelings get in the way of what the deceased person would have wanted, and that can result in either the court directing them to have to do it, or actually removing them and appointing somebody else.
Well, and that brings up something we've talked about before, ran into problems before. You just want one person to do that job.
Oh, absolutely. You can't do it by committee.
Well, and I've seen it with, I want, you know, all my children to be co-personal representatives. Yeah. It's a bad idea. Pick one, or pick a neutral third party.
Absolutely.
What if the people who are supposed to receive it, so like in this case, Dad wanted to leave the house to 3 children, wanted to sell it though. He instructs sell it and split the money. If the children agree to do something different, can they do something different?
If they all agree. This is not a decision where the majority rules.
Okay.
It has to be unanimous. So if the will directs that the property be sold and 2 want to sell and 1 doesn't, then the property has to be sold. Okay. If they all 3 agree for it not to be sold, or all of the owners agree, then of course they can keep it.
We've got Joe on the line from Decatur. Hi Joe, thanks for calling. What's your question tonight?
Thank you. My mother had a stroke and fell and broke her hip, and through much work we got her covered with not only Medicaid but Medicare in a rehab center. When she used her 100 days up,
they transferred her to the nursing home, and since Medicaid and Medicare were in effect, that was paid for. But it was not a tenable situation, and we moved her to an assisted living. Therefore, Medicaid was dropped, and I am working on VA benefits. And with the $2,000 limit, all that she can have with Medicare, her rent for the assisted living is more than $2,000. If something were to happen to her tonight and she had to go back in the hospital or back in rehab, would that automatically keep me from getting the Medicaid back?
It's a good question, and I think, you know, I could pick up the phone and I call Connie a lot of times, and she'll tell me this, and then I'll let her tell you the answer to the question. Medicare, it will pay for medical benefits if you are over age 65 years old or if you have been declared disabled on the Social Security Administration. They will pay for medical care. They'll pay for hospitalization. They will not pay for long-term care. They will not pay for assisted living. Medicaid will pay for long-term care, but it's got those income limitations.
That's correct. Now, I think what your question was, because she's now getting a VA check, or you're in the process of getting her a VA pension, would that cause her to be over the income limit for Medicaid if she goes back to the nursing home? No, it won't. A portion of that VA check is not countable towards the Medicaid eligibility limit. And Medicaid does have an income limit, but there's an easy solution to fix that income problem. So income is never a barrier to anyone getting on Medicaid. We can fix that without a problem. So if you have income in excess of $2,022, we can fix that.
Good. Let's take a break. We'll be right back answering more of your questions about elder law. Stay with us. Welcome back. We're talking about elder law tonight. Michael Timberlake from Senior Timberlake and League is here. So is Connie Glass from the Elder Law Firm. We've got callers waiting. Andrew is on the line from Huntsville. Hi, Andrew. Thanks for calling. What's your question?
Yes. If all of the assets that me and my wife own, if everything's joint, cars, vehicles, house, checking accounts, bank accounts, savings accounts, CDs, it automatically goes to the other one upon their death. Is that right, with no probate?
Talk to him about how things are titled.
The words are right of survivorship, right, Connie?
That's right. That's right. Yeah. If all the assets are joint with right of survivorship, then they pass to the surviving owner. There is sometimes real estate, for example, can be owned jointly, but not with right of survivorship, and does not automatically pass to the other surviving owner. It can be what's called tenants in common ownership, and sometimes assets are owned that way. And there are some assets that spouses own that they forget about. Savings bonds that you may have purchased through your work that were in your name only, shares of stock that you may have inherited property that's in one spouse's name only. So a lot of spouses think they own everything jointly, but when we get down to looking at everything when they come in to do an estate plan, we find out that in fact there may be one or two little straggly assets out there that were not jointly owned.
Well, and to do proper estate planning, really you need to talk to somebody about the situation, because just holding them jointly or even jointly with right of survivorship may not result in the tax treatment that you want it to. If you've got a substantial estate, there may be reasons not to just give it to your spouse. You want to pass it down to another generation so your spouse doesn't have to do that. So, you know, if you've got a substantial estate, you know, don't just think you can do it yourself. Go talk to a lawyer, and it's not an expensive process.
You're exactly right.
We've got Mike on the line from Florence. Hi, Mike. Thanks for calling. What's your question?
If you are deeding over some property to your parents so they can build a house on your property, which would then be their property, and they keep your name on the deed, I guess, so later on as they pass away, you take ownership of the property. As they're building, if something happens on the property, can you be also held liable?
Ooh, complicated.
If you are an owner, you're just as liable as the other owners. Yes.
So possibly so.
Right.
Possibly so. Well, you're the liability guy.
Well,
so.
you know, from that situation, you'd have to be, you know, determined to figure out what you did wrong, you know, and just because you own property and somebody's on your property and they get hurt doesn't make you automatically responsible. It depends on the reason they were there and depends on what you knew or should have known about the property. But as an owner, yes, you could be pulled into the situation if somebody was injured on the property.
And we've got Kathy on the line from Albertville. Hi, Kathy. Thanks for waiting. What's your question tonight?
Oh, well, my question is, I have an aunt who is, she just recently got disability. She has no insurance. They say she can't get the SSI because of her income is too high. I heard you say something a while ago that the income could be adjusted or something.
That's only for Medicaid in the nursing home, not Medicaid outside the nursing home.
So if she needs to go to the nursing home.
Yes, ma'am. If she was in the nursing home, she could qualify for SSI and Medicaid. Oh, excuse me, for Medicaid long term. But if she's outside the nursing home and she's receiving Social Security disability, she has to be receiving disability for 24 months before she can become eligible for Medicare.
Yeah, and that, you know, that's a difficult situation where people, you know, there's 24 months there, they're hanging out, they don't have any health insurance.
They're
it's
disabled,
really scary.
can't work.
Right.
Yeah.
Crazy. If you didn't get your questions answered tonight, let's tell you how to get in touch with these guys. Here's how to reach Connie Glass with the Elder Law Firm in Huntsville, 256-536-9494, and the website elderlawfirm.net. Here's how to reach Michael Timberlake with Senior Timberlake & League in Huntsville, 256-536-0770 or 800-804-2502. The website law-injury.com. You can also check them out on Facebook. And I'm a family law attorney in Huntsville. Divorce, child custody, 539-7337. Next week, we're going to be talking about injuries, all kinds of injuries. So stay safe, but call in your questions next week. Thanks for all your questions tonight.